I hope it's correct. Hello, everybody. It's my honor and pleasure to be with you today. I will try to present how we deal with the liquidated or delayed damages in Romania. And as many other countries, civil law countries, our legislation was influenced by the French civil law, respectively by the Napoleonic Code. The new, we call it civil code, it's in force since October 2011, used as an inspiration sources the Quebec civil code in particular, but also the French, Italian, Spanish codes, and also the Swiss code of obligation. As such, it is considered to be quite modern. Next slide, please. We also have, made my presentation based on the question I received for the organizers. So the first question, the simple answer is no. The liquidated damages are regulated by the law in, for example, the civil code, because we have also other piece of legislation that come and fulfill all the image of the liquidated damages in Romania. But under the Romanian law, the creditor may always ask for the performance of the obligation, the performance in kind, we call it, except when the obligation became impossible to be executed. When the debtor does not perform the obligation, then the creditor, only the creditor, has the right to choose between asking for the performance in kind or the execution by equivalent. This equivalent is named compensatory damage, and it cannot be cumulated with the performance of the main initial obligation. But when the obligation is executed in another place than the agreed one, or in case of a late execution, then the moratory or moratorium damages are applicable. The damages related to the late execution, the late performance, are known as delayed damages, penalități de întârziere, and we generally use delayed damages and not liquidated damages term. Moratorium damages can be cumulated with the performance of the main obligation, for example, execution of the works. The moratory damages can also be cumulated with the compensatory damages when the creditor choose to give up to the asking the performance in kind and ask for execution in equivalent. The punitive damages, daune combinatorii, are not based on the proof of a loss, as their purpose is to complete the debtors, to compel the debtor to specific performance in a specific period of time. An example could be those penalties that the employer introduced for the late submission by the contractor of a monthly progress report in a FIDIC contract. But they are not relevant for today's discussion, even if they are also under the same regulation. Next slide, please. This slide shows a way in which the moratorium damages are applicable to in the case of a to-do obligation, because under the Romanian law we have obligation classified in the obligation to give, when we have a transfer or a real right, or not an in rem obligation, as it is the right of ownership. Obligation to do something, for example, to execute the works, and obligation to not do something specific. So we have here the regulation for the obligation of to do something. The Civil Code establishes the right of the creditor to moratorium damages, to liquidated or delayed damages. The law also establishes how these liquidated damages are to be applied and calculated. The legal interest that the text speaks about is established by a different piece of legislation and can be changed during time. But the fact that the legal text expressly states that the provision is applicable only in the case in which the parties do not agree on a penalty clause identifies this provision as a suppletive norm, meaning that it's become mandatory only if the parties are silent on the matter. One more observation I want to make here. There is a piece of legislation, a government ordinance, which regulates the interest, which could be punitive interest or a penalty interest or late payment interest, that states that the interest, the liquidated damages, must be always established in writing. But what is a penalty clause under Romanian law? Next, please. Under the Romanian law, the penalty clause is a conventional assessment of the compensation for the damages suffered or not, it doesn't matter, by the creditor and caused by the unjustified non-execution of the agreed obligation by the debtor. It is important to note that this assessment and the agreement must take place before the damage occurs. Next, please. Here you can see, and I wanted to show you that even if we talk about the delay damages in general, a penalty clause may provide not only for a late execution performance of the obligation, but also for other situations in which the obligation is not executed as it was agreed. Next. One of the problems, if not the most important one, is how the liquidated damages are considered in Romania. Compensation for damages, a remedy, or a penalty, a sanction. As it was already said by the earlier speakers, the problem is that under the common law, the penalties cannot be obtained. Anyway, we do not have this problem. Traditionally, liquidated damages have a double nature: compensation on one hand and sanction, a penalty, on the other hand. The doctrine oscillates from one to the other based on the different influences at a certain point of time. But even so, the doctrine recognizes the role, the combinatory role of the liquidated damages, considering that the liquidated damages contain a warning of punishment in case of late execution. But the new code stresses the remedy nature, the compensation nature of the liquidated damages by its definition. But as you saw 2 slides ago, the liquidated damages, the penalty clause, is a conventional assessment of the compensation in case of late performance. Anyway, the code still uses the term of penalty, for example, when it talks about the reduction of the penalty. And for the parties, all these theoretical discussions are not quite relevant as long as the law allows the liquidated damages to be enforced, recognized and enforced. Next. So we go to the next question that I received for the organizers. If there a limit, a maximum percentage or liquidated delay damages to be regulated by the law? The answer is always no, but we have a rule: the court cannot modify in any way the quantum of the penalty clause or the liquidated damages or the delay damages, but this push enter. Again, we have an exception: reduction of the amount of penalty. And this is the title of the legal text, and you see that it is used the word penalty. So the next question is if there is an amount allowed by Romanian law. There is not. Better said, that is not a certain limit, but we have a mechanism control of the value of the liquidated damages. This control mechanism was put in place to limit an eventual upper force position of the creditor when concluding the contract and when the parties agreed upon the value of liquidated damages, and to avoid unjustified enrichment, which will be an expression of bad faith. Next, please. So the condition when the court may reduce the quantum of the penalty. The court may reduce the penalty. And when we talk about court in Romanian, the Romanian law says, if we speak about the courts in general, we refer to both the state courts and the arbitral courts, as long as the object of the dispute may be solved by arbitration. So the court has the possibility to reduce the quantum of the penalty only where the main obligation has been partially executed and this execution have benefited to the contractor, to the creditor. And the second situation, the penalty is obviously excessive, so not just excessive, obviously excessive compared to the damage that could have been foreseen by the parties at the conclusion of the contract. Please observe, again, it's about excessive value of the quantum of the liquidated damages, because only an obvious, evident difference between the liquidated damages value and the damage may lead to the reduction of the quantum of the penalty. But the penalty, the liquidated damages remain valid even after the reduction of the value. And always the value thus reduced must be superior to the value of the main obligation. And important, these liquidated damages are applicable even if there is no damage or prejudice suffered by the creditor. The reason for this is to avoid the bad fate of the debtor, and this time, if he will prefer to pay less instead of executing the main obligation. If the Article 1541 that you have on the slide situates the LD somewhere in the middle between the limited liquidated damages as compensation and liquidated damages as sanction, because, as I said, only an obvious excessive value may be reduced. But the Romanian regulations are not perfect. If usually there are no problems with accepting or enforcing the liquidated damages clauses, there are still issues about which the courts see the matters differently. Next slide, please. So, as I said, usually when the law speaks about courts, it refers to both state courts or arbitral courts. And also, usually, there is no difference between the solutions that are given by the state courts and those given by the arbitral courts, especially when we talk about the domestic arbitral courts, because they know the law. In the case of an international arbitral court or a foreign arbitrator, is the obligation of the interested party to provide to the court all the necessary legal information, the legal provision that apply to the liquidated damages in dispute. And one of the main problems which appears quite often, is when the court may reduce the quantum of the penalty, meaning here that it's not clear if the legal provision is mandatory in the sense that the court may or even must act ex officio, even in the absence of the request of the party, of the debtor, or the court may reduce the quantum of the liquidated damages only if the debtor so requires, otherwise being a case of extra petita, when the court decides or gives something that was not requested. Another problem about which the courts are split in their opinions and decisions is if it is possible to increase the value of the liquidated damages, because some part of the court say if the law does not prohibit it, then it allows it. So theoretically, it is possible. But the other part of the court says, yeah, but you know, the liquidated damages, if are established by the parties, then the law doesn't apply. And if you want to increase these liquidated damages, this will be an exception, or by the rule of law, any exception must be expressly stated by the law, but it does not in this situation. So what if it's possible, but also the same part that it's against the possibility to increase the value of the liquidated damages, say, okay, we have the intention of the lawmakers they clearly stated in the government decision that adopted the preliminary thesis of the civil code and said the courts do not have the power to increase the penalty when it is inferior to the suffered damages. So we don't have a single opinion, but I think the majority is all somehow to the impossibility to increase the value of the liquidated damages. And another issue connected more with the protection of the consumer against abusive contracts. The problem is, if the penalty clause is found null and void, does become applicable the legal rules regarding the compensation or not? Some say that cancellation of this penalty clause is not the same as the situation in which no penalty clause was agreed. And because the law, those suppletive provisions we talk about, applies only when a penalty clause is not stipulated, in case of cancellation of the penalty clause, the creditor is not protected by these suppletive norms. To conclude, under Romanian law, the liquidated damages or delay damages, as we use the term, are possible. They are a common thing in the contract, and their quantum could be reduced by the court in specific certain circumstances. And with this, I want to say, come on, and ready for the questions.